Hi, my name is Matt Margolis, and I'm an attorney with Margolis Weldon. We're here today to talk about the importance of powers of attorney in HIPAA forms. At Margolis Weldon, we're passionate about the fact that every estate plan and asset protection plan should have powers of attorney as part of them. Powers of attorney come in two different forms in Illinois. There's one for healthcare and one for property. In the end, really a power of attorney is a document that everybody should have that's over the age of 18 years old. The reason for that is because once we turn 18, we are the only ones that can have access to our health care and financial information. And so by having powers of attorney, it allows us to appoint somebody else to be able to make those decisions for us if a situation arises where we can't, whether that's a temporary situation due to us being incapacitated or a permanent situation where we're incompetent. Powers of attorney allow us to name one person to act at a time, but we can name as many people as we want to in order after them. There are different rules for how they can be executed, etc. But the gist of the powers of attorney is that we're naming somebody to step into our shoes and to be able to take action on our behalf if we can't. In Illinois, if you don't have a power of attorney, you're over the age of 18, and something happens to you, ultimately the only way that we can deal with that situation and put somebody in place to make decisions for you is to go through the guardianship process, which can be long and drawn out and cost a lot of money, and it involves going through the court. On January 1st of 2015, there were changes that were made to the Healthcare Power of Attorney Act in Illinois, such that the person that we name, and we call that person the agent, does not have HIPAA authority. And what HIPAA authority is basically the access to medical records and medical information. And so because the power of attorney is done without that, ultimately it is obviously very important that we have a separate HIPAA form in place. And the HIPAA form, not to get mixed up with the Healthcare Power of Attorney, allows us to appoint as many people as we want to have access to our medical records and medical information in the event that we're taken to the emergency room, we're being transferred from one long-term care facility to another, or if we're simply being transferred to a long-term care facility for the first time. We want to make sure that our loved ones and the people that we want to be able to communicate with our doctors can do so, and we do that by using a HIPAA. So, thank you very much for listening to this short video, and if you have any further questions, you're more than welcome to contact Lauren Weldon or myself at Margolis Weldon.